one.
Father, we thank you for this day. Thank you for one of the many blessings of life. Lord, we know that you have placed us here and given us serious work to do for your people. We pray that you give us wisdom and moderation in all that we do, and we ask all these things in Jesus' name. Amen.
Thank you. All right, we have at least two visiting judges. I believe Judge Weaver, you want to raise your hand? And Judge Gunter, thank you for coming. Any other judges here today? I always like to recognize our colleagues on the bench. All right, we have three bills on the agenda today. We'll start with SB 1. Senator Parent, you can stay in your seat if you prefer.
Okay.
Whichever.
I will.
All right. Just a minute.
Okay.
You're not on. Harold, can you allow her to speak on yours? We're having trouble with number 7.
Then we'll switch back. Thank you, Mr. Chairman and members of the committee. For those of you who were in subcommittee yesterday, I apologize for a little bit of redundancy in the presentation, but figured I would walk through something similar to catch the rest of the members of our committee up to speed. I'm honored to have the opportunity to present CJ's Law for your consideration, Senate Bill 1. This bill provides the option of enhanced penalties for a hit-and-run driver who causes a crash that he or she knows caused serious bodily injury and then, instead of stopping, flees the scene of the accident. And what is the reason for the bill? Current Georgia law assigns the same penalty range of 1 to 5 years to drivers leaving the scene of a crash that results in a serious injury without regard to whether or not that individual was the cause of the crash. And so this legislation would change that so that the individual that caused the crash and flees has a penalty range of 1 to 10 years instead. So this would give more flexibility for prosecutors depending on the fact pattern of the incident, so that the most serious offender, the one that caused the crash and then or accident and then fled, could receive the most serious penalty. And this legislation arises out of the tragic case of Charlie Jones, or CJ, who was only 23 years old when he was hit by a car while walking in Cobb County in 2009. The driver of the car that struck CJ failed to stop, leaving him injured and helpless in the roadway, only to be struck and ultimately killed by subsequent vehicles. CJ's family, including his cousin Marcus Coleman, who you have all heard from, have worked tirelessly for justice in his case since that date. I also want to recognize Representative Abel Mabel Thomas, who's with us today. She's the initial House sponsor of this legislation and has spent a lot of time working on it. And yesterday, those of you who were here during subcommittee were also able to hear the testimony in support of this legislation from Ivan Shustak, who was injured by a hit-and-run driver last March while he was walking. That perpetrator rounded the corner, hit him in a crosswalk, knocked him down, and just kept going. This person who caused the incident was eventually identified, but it was only after the neighborhood sort of banded together, got a lot of security video footage so that they could find out who did it. And then while they were searching for him, they saw that the car they were looking for was, during the time, moved from the street into the garage in an attempt to hide the car because the individual knew that law enforcement might be after him. So the person was caught, but Mr. Shustak did testify with us yesterday that he physically will never be the same. And there was a video we didn't see yesterday showing when he was hit. that really sort of illuminates the issue we're talking about, and it's only 40 seconds long, so I was hoping we could play it now for the committee, and I can sort of explain to you what you're seeing, and it's interesting, especially after hearing Mr. Shusak's testimony yesterday.
Are you ready?
Okay, so yeah, so if you look at the screen, sorry about that, Senator Kennedy, you'll see Mr. Shusak start to walk down the sidewalk, an umbrella right there, see him? That's him coming in the sidewalk, and he's gonna cross to the other side of the road. And you can see he's knocked down, the driver just keeps going, and then another person comes to provide aid. And so, you know, this is very serious behavior, hitting somebody walking across the street and just keeping on going like nothing happened. And so the point of this legislation, you know, this is already illegal behavior, but the point of the legislation is to recognize the seriousness of this offense. Notably, though, it does not provide any mandatory minimums. The discretion would still absolutely be within the trial court to go anywhere between the 1 to 10 year range, depending on the fact pattern and the seriousness of the incident, and that would entirely be within the discretion of the trial court. So no mandatory minimums here, but it would clean up this segment of law whereby right now anyone hitting someone and fleeing is charged the same, regardless of whether they were the cause of the incident, and that's what this legislation seeks to address. So with that, Mr. Chairman, I'm happy to answer any questions, and I know that Mr. Samuels, who we heard from yesterday, may have some words from Prosecuting Attorney's Counsel.
Thank you. Do we have any questions for Senator Parent? All right, we have someone signed up to speak, Jason Samuels with Prosecuting Attorney's Counsel. You want to come up?
Thank you, sir.
Good afternoon.
Good afternoon, sir. It's an honor to be present with you again today. Senate Bill 1, sir, if I can begin, I am authorized on behalf of Mr. Pete Scandalakis, our Executive Director at the Prosecuting Attorney's Counsel, to report to this committee that the PAC does support the passage of this legislation. Senator Parent's explanation is very thorough, and if I can just echo that principally what this legislation does is recognize what we believe is the elevated responsibility for persons that are responsible for crashes to remain at the scene, provide aid, summon help if they can, to comply with the law. It gives to sentencing courts the discretion to sentence up to 10 years if the facts are believed to be warranted. It, again, contains no mandatory minimum, so a court would still retain full discretion to sentence anywhere on that range, including issuing a sentence of probation or suspending a sentence if a court believed that was appropriate. But again, I think it does recognize that we have an elevated responsibility if we are responsible for a crash that results in that serious injury to remain at the scene, to provide aid, to summon help, and to comply with the law.
Thank you. I have a question from Senator Cowser.
Thank you, Mr. Chairman. We had a little discussion in subcommittee about there being some scienter or knowledge of the fact that an injury was caused. I don't know if you and I have an agreement on that or not, but is there a way you think we could make this clearer to say, you know, that you caused an injury that you know has resulted in physical harm? I think we use the example, what if you bump somebody from behind, they don't complain of injury, no visible injuries, and everybody says it's okay, give me your insurance information. The next thing you know, you've caused a serious injury and left the scene of the accident.
Yes, sir. Essentially, in bringing this charge, a prosecutor is going to have to show a couple of things. The language of the statute reads as follows, and I'm looking at line 35 of the bill. It creates new subsection C for this code section, and it reads as follows: any person who, without malice aforethought, causes an accident that results in bodily harm and leaves the scene in violation of subsection B of code section 40-6-270. So essentially what a prosecutor is going to have to prove, a prosecutor will have to prove the underlying violation of hit and run, 40-6-270B. but will have the added element under this statute of also proving that the fleeing driver was responsible for the crash. Now, that's important because 40-6270B reads as follows. If such accident is the proximate cause of death or serious injury, any person knowingly failing to stop and comply with the requirements of this section shall be guilty of a felony, and upon conviction shall be punished by imprisonment of not less than 1 nor more than 5 years. So it's our position, sir, respectfully, that the knowledge element is present and would be required to be shown by a prosecutor through proof that would satisfy the elements of 40-6270B.
Okay. Yeah, could I ask one additional question, Mr. Chairman?
Yes.
Are you envisioning this as something that the same act can be a violation of both serious injury by vehicle and this, I'm going to call it leaving the scene of a accident with serious injury?
Yes, sir. Basically, the facts would support a prosecution under either code section.
So
40-6270B would, I think, in our vernacular, be a lesser included offense of the more serious offense that the committee is proceeding now. If, though, a prosecution was brought for both code sections, in the event a conviction was won for both, they would merge for the purpose of sentencing. So a defendant would not be exposed to sentencing under both.
all right, so it wouldn't be a consecutive sentence for this new, it would be concurrent or just merged into one?
Yes, sir. The lesser offense, the 270B, would merge into the what would be the new serious injury by vehicle statute.
Does that need to be articulated in this, or that's a principle of law?
No, sir, that's a matter of law. All the elements that are contained in 40-6270B would be contained in the new statute. In fact, we would have to prove that lesser offense in order to get a conviction on the new statute, plus the added element of causation. So, as a matter of law, they would merge.
All right. Any further questions from Mr. Samuels? All right. We have another person signed up to speak on the bill, Marcus Coleman. Are you nearby? Come on up.
Thank you, committee.
You're welcome. Good afternoon.
Good afternoon. Good afternoon again, Mr. Chairman. Won't be very redundant. Like Senator Parent said, most of you were present yesterday, and a lot of you were present last year. Just want to let you know, of course, this is my little cousin that we're speaking about, CJ. I've said over and over again the horrific nature as far as law enforcement and as far as medical examiner's office just added another layer to detriment and turmoil to our family. We aren't looking for any kind of vindictive justice with this legislation. As I said yesterday, smart cars and smartphones are getting smarter, and people driving are getting dumber. That's just how it is. And the legislation that you guys passed, again, last session with the hands-free, it is absolutely excellent. I did not really think I would enjoy it, but I'm forced to understand that it is good legislation. It is good reactive and proactive legislation, as is CJ's law. Senator Cowsert, we also talked yesterday about the loopholes that it helps clear up with subpar attorneys that can expose the current legislation. So it helps the criminal justice system. So there are a couple of groups that have signed on, and I'll close with this. Save Ourselves is a human, civil, political rights group. Mothers Against Drunk Driving, we had their support and still have it. Georgia Bikes, and also Atlanta Bike Coalition, because the cyclist would also fall up under this legislation. So I really hope I can give my aunt a great report on the way back today. Thank you.
Thank you. Any questions for Mr. Coleman? Thank you.
Thank you.
Does anyone else want to be heard on the bill? That's all we have signed up. Senator Cowsert?
Mr. Chairman, could I ask the author one question? Because
Yes,
my
go
mind keeps chewing over this.
Go ahead.
I don't see how, if the offenses merge, that this changes anything. I don't see how you can possibly leave the scene of an accident that caused serious injury that now subjects you to 1 to 10 years without also having already violated the serious injury by vehicle statute, which currently subjects you from 1 to 15 years. If the prosecutors just say that this is not, can't be added onto it, it's gonna merge in with the lengthier offense to begin with, what have we done? I mean, all the you have to have first committed serious injury by vehicle to have left the scene of an accident that caused a serious vehicle injury. And he just said it's a lesser included offense. I don't get it, how you could possibly violate this subsection B with, or C without having also violated B that has a greater penalty already.
You want to respond, Senator Parent?
Well, I'm looking at legislative counsel over there, as well as, I would refer back to my expert on the code section, Mr. Samuels, because while I wish I was a total expert on all of these code sections, Senator Cowser, I must confess that I probably am less knowledgeable than others in the room.
All right, Mr. Samuels, can
Yes,
you
sir.
enlighten us?
So the serious injury by vehicle statute that we have now, essentially, there are two predicate offenses for that: reckless driving or driving under the influence of alcohol. So to prove serious injury by vehicle, the state is going to be required to prove the commission of one of those two predicates, either a reckless driving, driving in reckless disregard for the safety of persons or property, or driving under the influence of alcohol or drugs, essentially a person being in control of a moving vehicle while under the influence to the extent that they are less safe, or in violation of the statutory alcohol concentration limit. Presently, the serious injury by vehicle statute, and I think this is what this legislation is meant to correct, does not speak to the offense of hit and run.
Unless it was, excuse me,
Go ahead.
unless the driver was
Drunk.
DUI or driving recklessly.
That's correct, sir. So,
And that is, if I'm correct, that's, if you look at line 31, sections 40-6-390 or 40-6-391, 390 is recklessness and 391 is DUI.
All right,
Am I correct? That's right.
that's right.
okay. Anyone else want to be heard? Don't see any. What's the pleasure of the committee? Oh, hold on just a second. Senator Rett? Okay, you're recognized. All right, motion by Rett, second by Jones. All right, we have a bill before us. Senator Heath?
Mr. Chairman, I assume this is discussion.
This is discussion.
On line 31, there's a change here that says that this is while violating Code Section 40-6-390 or 40-6-391. Then it goes on to say, shall be punished by imprisonment for not less than 1 year. 390 and 391 both say that you're punished by not more than 1 year. So how does this work together? That you got to violate one code section that says less than 1 year, and then you're in violation of another section that says greater than 1 year.
Go ahead.
Thanks. I may need you, Senator Heath, to repeat part of your question and probably get advice from the experts. But I did fail, as I did yesterday in the subcommittee, to walk through the bill. So it did occur to me when you were speaking that I did not mention that A, while it looks like new language, Section A is just moves the definition of serious bodily injury into a different subparagraph. It's the same as the law. And Section B essentially is also just a restatement of the law, although it does tighten the language up a bit. The only substantive change in this legislation is actually Section C, and I should have pointed that out earlier. However, you, I believe, are saying that there's what sounded to me like that there's a typo in here where one section says less than and one says more than?
Well, I don't know if it's a typo or not, Mr. Chairman, but line 34 says that if that you shall be guilty of a felony and shall be punished by imprisonment for not less than 1 year. Both 390 and 391 both say that the punishment shall be less than 1 year. So you got one that's saying not and one that's saying that it is.
And that would, I
don't-
assume, be
don't- I
current
don't know.
code.
I guess there's no punishment. I mean, you can't comply with both sections, if I'm reading this correctly.
Well, I'm not looking at,
Line 34 and line 39, he's comparing.
No. I'm saying that Code Section 40-6-390, the penalty there is that you are punished for not more than 1 year. And 391 has a variety of punishments, but it's not more than 1 year. This says that while violating one of those two code sections, that you shall be punished for not less than 1 year. And I don't know which code section would apply when it's the same offense.
I think Mr. Samuels wants to weigh in.
Or perhaps if you,
All right.
maybe this is saying that if you cause bodily injury, then everything in those other code sections is thrown out.
Mr. Samuels,
Well,
you understand the question?
I think I do, sir. Thank you. Senator Heath, I think possibly what you're referring to is a violation of reckless driving, 40-6-390, presently is codified as a misdemeanor, and the maximum punishment that a defendant could receive is 12 months incarceration or a fine of $1,000. DUI, if it is a first, is very similar. It is a 12-month sentence. So either one of those offenses standing alone would be misdemeanor offenses. Maximum punishment for either would be 12 months incarceration or a probated sentence of not more than 12 months. What our serious injury by vehicle statute does is add the element that if one of those offenses results in a serious injury as it is defined in the statute, then it becomes a felony offense punishable by 1 to 15.
All right. Does that answer your question?
So if you're going to punish under this code section, then you're no longer drunk or you were no longer driving recklessly?
No, sir. Very similar to what the state would be required to do under the proposed legislation. Presently, the serious injury by vehicle statute would require the state to prove the commission of an act of reckless driving or the commission of the act of DUI. And we would also be required to prove beyond a reasonable doubt that one of those offenses, the violation of either the reckless driving or DUI statute, resulted in the serious injury of a victim. It's that additional element, the serious injury resulting from that act, that would elevate it to a serious injury as it is drafted now and as it exists now.
All right. Any other?
And again, if I can just echo Senator Parent, subsections A and B of the new legislation found at lines 23 and lines 27 essentially are a statement of the law as it exists today.
All right. Anyone else want to make a comment or ask a question? All right. That amendment has been worked on. Senator Parent, do you want to describe that, or do you want me to?
Are you speaking
Right.
of the language by Mr. Smith?
Yeah.
We did have discussion. Thank you, Mr. Chairman. We did have discussion that we could tighten up the language somewhat, getting to the conversation that began yesterday with Chairman Cowsert, where we could add proximately before causes to just have the scenario be tight. And then while I don't believe it's totally necessary, I would be amenable to having knew or should have known results in bodily harm. And that way there's the cross-reference to Section 40-6270 would not be necessary, and it would be more clear what the statute does.
All right. Have you, you understand that amendment?
I do, sir.
And PAC doesn't have a problem with those?
We do not.
Okay. Senator Tillery?
Thank you, Mr. Chairman. Do you mind, Senator Parent, telling us where you were inputting those words at? I was trying to copy it down.
Yeah, of course. Thank you. put approximately after the comma before causes. And then before results, we would put in the person knew or should have known results in bodily harm. So between accident, right after that and before results.
I think this deals with a situation where you have to show that the person knew he didn't hit a dog, or that-
Serious bodily harm to an individual.
and that it's a
Right, and we-
knowledge requirement.
Yes, because there is a knowledge requirement in 4-60-270, as Mr. Samuels described. And so this, inserting it here as well would, of course, make it clear that that knowledge requirement is incorporated into the new law that we would be putting forward.
All right. Senator Cowser.
I just want to say, I do appreciate that. That was the concern that I had raised. And I agree this clarifies the law rather than referencing you somewhere else. Although the or should have known was not my language. Mine was that you knew. Because I think you're back injecting ambiguity again. Heck, now you've got to prove that a person should have known somebody was hurt without having actual knowledge of it. So yours is softer than what I had suggested yesterday, but it certainly begins to address my concerns. Thank you.
All right, now that has not actually been moved as an amendment. Is there?
I'm willing to move that amendment, Mr. Chairman. The amendment that I just described, do I need to walk through it again?
I don't think so. Did everyone understand the amendment? Okay. No.
And I will, one comment if you indulge me, Mr. Chairman. We wanted to ensure with this language, Chairman Cowser, that someone couldn't sort of intentionally try to evade, and that the sort of knowingly typically also encompasses the reasonable person standard in general under all aspects of the law. And so just like adding the knows makes it clear that that is a requirement of this, adding the should have known also makes it clear that it tracks the rest of law, and doesn't create sort of unnecessary loopholes for creative lawyers. So maybe you and I can have a happy marriage on that by adding them both.
All right, there was a motion to amend. Is there a second? Second by Senator Jones. Any discussion on the amendment? Hearing none, all in favor of of amending the bill signify by saying aye.
Aye.
All opposed, like sign. Okay. It has been amended for the purpose of creating a new substitute. Now that returns to consideration of the bill as amended. Any further discussion? Hearing none, signify all in favor by saying aye.
Aye.
All opposed, like sign. It passes. And that is
Thank you.
LC 440971 as amended to create a new substitute. All right, we move to the second item on the agenda. That's Senate Bill 10. Senator Jones, you want to stay in your place or
Yes,
move?
yes, sir. I can stay, Mr. Chair.
All
That's
right.
fine.
Oh. So you're switching places to get the mic. Go ahead.
All
when
right,
you're
thank you,
ready.
Mr. Chairman. This is Senate Bill number 10, and I believe most persons were actually here yesterday, if not actually on the dais. And Senate Bill number 10 makes a couple of changes to current misdemeanor marijuana law, and the changes are, number one, currently in Georgia, a misdemeanor is basically up to 1 ounce of marijuana, which can be punished up to 12 months in confinement, up to $1,000 fine. So it does two principles. Number one, it states that up to 1/2 ounce would be they're still misdemeanors. It would be a misdemeanor, still is a criminal act, but it'd be a misdemeanor, but shall be punished by a fine of not to exceed $300. So that's step one. And then step two states that the weight would be more than 1/2 an ounce, but no more than 2 ounces would then also constitute a misdemeanor for imprisonment for a period up to 12 months and a fine not to exceed $1,000. So what we've done is we've changed the misdemeanor amount. Currently the misdemeanor amount is 1 ounce. We've moved that up to 2 ounces. Within that, we have stated that up to 1/2 ounce, the punishment would only be a fine of up to $300. But it is still a criminal offense. It just says that the only punishment under that level would be up to $300, but it's still a misdemeanor offense. And to get there, I passed out yesterday various laws from different states, and I would just state that on this particular issue, Georgia's still behind. There are 36 states which actually punish marijuana less restrictive than Georgia does. So that's 36 states. There are actually 6 other states which may be comparable, but within their structure, they actually are less restrictive. And I'll give you a couple of examples. One is Mississippi, for instance. Its level of marijuana, which constitutes a felony, is 30 grams, which is basically just over an ounce. But you actually have the first lifetime, second lifetime, and third lifetime are just infractions. Those are not even criminal offenses. They're just civil infractions. Within that, also, Alabama, for instance, says any amount, if for personal use, will be deemed to be a misdemeanor, first lifetime. So you have different states like that. So you have 36 states which actually are less restrictive totally. And then you have 6 states which have similar laws, but within there, they're still less restrictive. And that was 2 examples. And then from there, you were basically just left with Georgia, Indiana, and Virginia, which basically does not move at all from this and says that it's going to be punishable, misdemeanors punishable up to $1,000 fine. This bill actually did pass pretty much in its same form. There are some changes that I'll make note of, but it did pretty much pass in the same form 2 years ago, and we're presenting it again today. One of the issues, Mr. Chair, was I believe lines 34 through 39, and well, excuse me, 31 through 34. And what we did was we changed that, and I can direct you to there. That's page 2, and that's J1. So that change is, it shall be unlawful for any person to manufacture, deliver, distribute, dispense, administer, purchase, sell, or possess with intent to distribute marijuana, or to possess 2 ounces or more of marijuana. There was initially a concern that we may have combined the two and made it more confusing. So we're hoping that that has actually alleviated that particular problem. And also in doing this, I would make note that not only has Georgia, of course, over the last few years talked about criminal justice reform, I would make note that even within the marijuana statute itself, we can see that the way we have been looking at drug use is more from a therapeutic standpoint. And that is within OCGA 1613-2, which is our conditional discharge statute, which basically has key language which says, part of the statute, that preferably, if it's a first lifetime offense, preferably the court would actually sentence a person, for lack of a better word, sentence a person to terms which require the persons to undergo a comprehensive rehabilitation program. So we have already, since 2010, looked at these issues as one of rehabilitation. We're trying to encourage that. We're trying to encourage persons to become more active in the community. This bill, I believe, strikes that balance. We still have a criminal offense. We talked about, over the last few years, we've talked about fines. So we've lowered the fine, but we still have the carrot to where you have a fine that goes up to $1,000. So we've lowered the fine in one level to help meet our concerns about fines and fees, but at the same time we've kept that fine at a certain level, at the $1,000 for misdemeanors, if it's above 1/2 ounce. We have concern about incarceration. So we've eliminated the incarceration up to 1/2 ounce, but we still have credible, reasonable incarceration possibility for misdemeanor marijuana above 1/2 ounce to 2 ounces. So I think this is a balance that we've been looking at. And I'd also point, when you talk about 1613-2, please remember that a person who's charged with a non-violent property crime and also charged with a narcotic can actually go through conditional discharge. That's what this state has been doing. So the overwhelming evidence really is that this state is trying to move in a direction of less penalty. This keeps penalty phases, but at the same time, I think it keeps fairness as far as where we of a state has been going, and also as far as nation has been going. So certainly, my argument is that I prosecuted for 10 years. I left prosecution to run for the Senate, which, you know, sometimes I regret that all the time, but I left prosecution to run for the Senate. I still be a prosecutor today. I was the very first African American ever hired in the Richmond County Solicitor's Office as a prosecutor. So I take, you know, my role as that, and people who have been on this panel before, no, I still say us and me when I'm talking to the prosecutors. I left because I had to run for this. That's my passion. So this is not designed to harm the community. I think it actually continues to bring the community, meaning the whole state, in line with our criminal justice efforts. And I would accept any questions, but would also request a positive vote for this particular bill, Mr. Chair.
All right, I have a clarification.
Yes.
The changes that you alluded to that are now at lines 31 through 33, does that, in your opinion, make it clear that intent to distribute or distribution in any form or fashion is still a felony?
Yes, I think.
Regardless of amount?
Yes.
Okay.
I do.
All
And
right.
that's the key.
All right. Senator Kennedy.
Goes to, it's me.
Oh. Senator Strickland.
Good question, Senator. So even though we've taken away in the bill jail time for conviction of 1/2 ounce or less of marijuana, someone that's charged with that offense will still actually have to go to a jail and be booked, fingerprinted in. Is that right?
That still is correct. Now, yes, that is correct. There are some sheriffs that may not actually take it that route, but as far as state law is concerned, it's still going to be a fingerprintable offense. And I guess what I'm getting to is what some jurisdictions are now doing is allowing that to be still written as a ticket. It's still a crime, but written as a ticket, and then fingerprinting at a later time. Now that's not mandated in this bill, though.
Right, as I believe under, I think it was Senate Bill 406 last year that I carried, part of the criminal justice reform package. One of the things in there we discussed, one of the issues with the bill that was brought up was whether or not someone would still be booked in and fingerprinted in.
Right.
And there was a part of that bill that required, I think it's a violation of 1613-2 to still be fingerprinted
Right.
in, which would be covered under this, I believe, if I'm right on that.
That's my understanding too. They still would be fingerprinted.
Thank you.
It is still a fingerprintable offense.
All right. Senator Cowser.
Thank you, Mr. Chairman. I don't take issue with your bill, but I just want to point out something, that you have now made the penalties less for possession of a 1/2 ounce or less of marijuana than the charges and the penalties are for possession of alcohol by a minor, because it has your same fine but up to 6 months imprisonment, which is routinely on a first offense
Right, they wouldn't
probation,
go.
so you can make them
Right.
go to do community service or get the education course. So I just don't know what message we're sending by saying we think it's better to smoke weed than it is to drink alcohol, or it's a less serious offense. Maybe you need to reduce the charges or the penalties on the alcohol as well. I just wondered if I'm not missing something, is that what this does?
We may revisit that too, Senator Cowser, but that certainly is not our intention to encourage persons to use marijuana at all. The key thing is to try to avoid the penalties that we've been avoiding anyway, which is the fact that, quite frankly, we've been saying we really don't want persons to have these high fines and fees. That's one of the key things. In fact, now with probation, if you only have fees only, you basically, I believe, can only be on probation for 3 months now. So that we're just trying to keep that in line with that, and so that certainly could be something to be looked at. We've done a good job in Georgia doing it. I just think this is a continuation of those efforts. But I do appreciate your point there.
All right. Senator Tillery.
Thank you, Mr. Chairman. Senator Jones, two things. I know you were clarifying things in line 33. That I'm going to support your bill, but the calls that I have gotten are about clarifying that. I appreciate that language. I ask you to consider it. I'm not going to make the motion. If you want to make and include it, to add after the word the first time you use marijuana in 33, so it would read intent to distribute marijuana of any amount or to possess 2 ounces or more. I know that that's in a lawyer language. It doesn't mean anything to lawyers, but it might mean something to who doesn't have a law degree who's reading that code. If you'll consider that. My second question, and again, if you don't go that way, I understand. I understand the law works that way either way. In section 2.-2, though, the probate court jurisdiction, I don't know enough about these code sections to know this answer, but are we giving probate courts jurisdiction of possession of any amount now?
Can you answer that?
I think when you're saying under code section 16-13-2, which would be this particular section, I think it would still just be in the misdemeanor amount. Okay. That's just my interpretation of it, and that counsel can answer. Yeah, okay.
Legislative counsel concurs. All right, anything else?
No, sir, thank
All
you.
right. Senator Ligon.
Thank you, Mr. Chairman. Just a couple of questions. The first is, for states that have relaxed their possession of marijuana laws over the last 10 years or so, do you have any data that shows whether the use of marijuana has actually increased or has it decreased?
I would say this: the data that you'll find is it's going to be incomplete. Let me give you one thing that you're going to look at that you may be pointing towards, and that's the question of marijuana and traffic accidents, and that may be something we can do more so, because you may actually find something to show that, well, traffic accidents increase. So let's deal with that. NHTSA actually came out with a couple of studies the data is mixed, and one of the reasons is, which Georgia does not do, and this may be one of the things you're alluding to, we still do not have per se as far as marijuana is concerned. Some states who have legalized it have now gone to what they call per se. So in other words, in Georgia, and it's a very difficult standard, quite frankly, we have to still show that a person is less safe as far as marijuana is concerned. It's not easy to do, quite honestly. So what other states have done, if they're now going to a per se. Whether that's good or bad is debatable. But what you have found is, because they went to that, you may see some areas where crashes have spiked up, but the level of impairment has not. It's just because you're at per se. And that may be one thing, but that's only because you've gone to per se. And Georgia's less safe, and per se would be something we may want to think about going to. It's different debates about whether we should or not, but it's very, very difficult to prove less safe.
By per se, you just mean that if you're found to have marijuana in your system, you're presumed to be driving
correct.
impaired.
We don't do that, and so that may be one thing that you have seen, but you have to understand that we're not comparing apples to apples there at all. Like if we took away the .08, which we can't because of federal funds and things. If we took away Georgia's DUI .08, you would see a whole lot of persons not being prosecuted for DUI. Okay. Because some people can drive .08 and look perfectly fine, but they're not. They're 08 and they're not fine. If you go through testing and things of that nature, you'll realize that, but you'll have more difficult time proving it. Georgia's not used a per se amount in marijuana, and it's something I know has been talked about, and it maybe still should be talked about. Proving less safe for marijuana is very difficult to do.
All right. Go ahead. You can continue.
One more question. This goes to what I think Senator Cowsert was alluding to on lines 21 and 22, where we're removing the penalty for jail for a smaller possession of marijuana, but You know, one of the tools that a judge will use, if you, especially have a young person coming into court, is that threat of jail to get them to go to maybe either drug treatment or some kind of treatment to allow them to understand the dangers that they're facing by the continued use of marijuana. And it seems like we're taking that, and that's a very important, valuable tool. And I mean, I was a judge for 16 years and did it, and I used that and did that. And all of a sudden we're taking that away from that judge, and that's something that can really be beneficial to the person that's brought into court. It can turn their life around and save them a lot of grief and heartache if they were to continue using the drugs and get into something more serious. And that's a concern that I have, and I don't know if you wanted to address that concern.
It may be somewhat, but I would also say this, that I don't know if there's any definitive data that everybody that comes through would need that. And I think that may be something that we actually look at to say, well, everyone, you can't, if you're actually going to make any kind of argument, I'm not saying you are, but if we're going to say that, okay, everyone that comes through, we want to have a stick to actually put them into rehabilitation, then we're actually making the point that we're not treating this anymore as criminal offense. We're actually making that point, that we're actually moving away from doing a criminal offense. And that way, we ought to look at really revamping these even more so, because we're really confessing to some extent we're looking at this more as rehabilitation. And that should be a conversation that we should have, without a doubt. But I do understand the concern, but I've just looked at so many other states, and you have the data that I provided, many of those more Republican than Georgia, and just hadn't seen any major deleterious effects by some of their changes, which are more drastic than Georgia, much more drastic than Georgia. This is extremely tame. Very few activists actually liked even this bill. Okay, this is the bottom, quite frankly. I'm not gaining very many friends, I can guarantee you that, on either side.
All right, Senator Kennedy.
Thank you, Mr. Chairman. This really is a question maybe to the author and to Legislative Counsel. Looking at line 16, I noticed the beginning of that says, notwithstanding any law to the contrary, and then the original text reads as it does. This replaces the beginning part of this subsection B which says, it shall be unlawful for any person to possess. I'm just wondering, from Leg Counsel's position or the author, is there any significance to not having the notwithstanding any law to the contrary in the statute as it would read now as proposed? And I don't know that it does or doesn't. It just, my assumption is that there was some reason that the original text said notwithstanding anything to the contrary, and by removing that, is that changing anything from?
Let's ask Mr. Tolbert if he wants to comment on that.
No, from my look at it, that language was just notwithstanding there wasn't anything found in the law to be notwithstanding to apply to that. So it's just extra language that we could strike.
Okay,
Yeah.
Thank you.
Right.
Mr. Chairman, one other question, please.
Yes, go ahead.
And to the author, Senator Jones, so as this would work, as I understand it, if someone is caught with 1/2 of an ounce or less, they're going to receive a fine, not any incarceration time.
Correct, which normally they would not in any event.
Normally they wouldn't, but under the statute, it's possible that they could.
It's possible
Right,
that they could.
okay.
This would
And
basically eliminate that.
And that's one of the fundamentals that's being changed by the proposal.
Correct. That would be
Okay.
one of the fundamentals that's being changed by the proposal.
So my question is there any limitation on the number of times that someone can be given a citation, if you will, or a fine or a speeding ticket almost for having 1/2 of an ounce of marijuana? Or is there, after a certain number of times of getting the ticket, it kicks up into a higher level where you could be incarcerated?
No, not at this time. But the question that I think there is a legitimate question about whether they can still come under 1613-2, but I'm not sure about that. So let's just assume there's no jail time at all. there would not be a trigger that would say, okay, at this point in time, you're going to go to jail. I would also think that at that point in time, if a person is bringing themselves that much into, then they really need to have some type of treatment. Would not be, and we're moving away from that, and we should be.
Yeah,
And I understand kind of how like having that carrot and stick approach. I totally get it,
Yeah.
without a doubt.
And I'm not debating that issue at all. I'm just wondering from a practical standpoint, does this mean under this proposed language that if you know the law and you're smart about it and you're a marijuana user, as long as you have
And half an
less than
ounce.
1/2 of an ounce on you, you know you're never going to go to jail. You're just going to pay a series of fines every time you get caught. Would that be
Well, I
fair
can say how some
characterization?
states have kind of dealt with that. I can say that. Let me tell you how some states, which I don't think Georgia wants to do, and remember I mentioned Mississippi, they would say, okay, we'll give you 3 bites of the apple, but it won't even be a criminal offense. And then the next one that you do, the 4th lifetime, I believe actually does go up to a felony. So you'd have 3 infractions, civil offenses, but it would be odd to say you get 3 criminal offenses and then we kick it up to something else. What you find some states doing, that being one and a couple others, they say, okay, we'll do what you just said. We'll give you a couple of bites, but they're still not criminal offenses at all. So that would sort of like be the trade-off if you wanted to go that route. But see, that's what I'm saying. Mine doesn't even go that route. These are still fingerprintable offenses. They're not civil offenses. But that's how other states have dealt with that idea of, well, let's give them 2 or 3 times, but it's only going to be a civil offense, and that's not what this is.
Yeah,
Yeah.
and I appreciate that distinction. I appreciate what other states have done, and maybe that's somewhat informative, but obviously not compelling on us on how we want to do
I
it.
understand.
But, so, notwithstanding what you just said, there would not be a limitation on the
There
number of
would not
times
be.
that you
There's-
could get a
there's-
ticket, so to speak, for
There would not be.
possession. Okay,
Mhm.
thank you.
All right.
Senator Ligon.
Yes, just a quick question, going back to what Senator Kennedy had raised on line 16. By striking the words "notwithstanding any law to the contrary," are we impacting the laws that have been passed allowing people to have possession of the cannabidiol oil? And it has THC in it. And I don't know if there are any laws in our state. I thought there was a law that allowed you to use marijuana to treat, was it glaucoma? I can't remember.
But not smoking it, though, are they?
Was that,
Not
or
smoking it, I don't think.
okay.
But I'll let
But-
council on
Yeah,
that
but-
drafting
but
issue.
I don't know if it would impact those laws.
You want to comment on that, Mr. Tolbert?
Sure, what the question was if it impacts.
The laws dealing with the cannabidiol oil that we've passed, they do have, you can have THC up to what, 0.5?
I see your point, but I'm not sure. But also there, I mean, if the committee would like, notwithstanding, just to make sure
Right.
that
We can put that in.
all bases are covered, that language can be added back in
Absolutely.
Yeah.
as a safeguard. So
Mhm.
All right.
Well, I don't know I don't know that fixes it. I think you have to say that this will not apply to any, is that right?
I don't know about that. You can just say notwithstanding any law to the contrary, yeah.
All right. Any other questions or comments before we hear from persons who have signed up to speak? All right. Hearing none, we'll call Stanley Atkins II. And would you tell us who you're with?
Yes, my name is Stanley Atkins II. I am the Georgia chapter president of Minorities for Medical Marijuana, and I am providing my testimony today as a citizen and not as a representative of any distinct organization.
Go ahead.
Thank you, Chairman Stone, Senator Jones, as well as the entire committee. I'm here today in regards to the SB 10 that has been promoted. Current drug reform advocates and statistics have shown that minorities are arrested at a disproportionate rate as opposed to other demographic groups. A cannabis arrest can derail an entire life in the state of Georgia. Spring break will soon be upon us, so let us take this time to review this law as a perspective from a college student. If a Georgia Tech student was arrested on spring break outside of the city of Atlanta or one of the decriminalized jurisdictions, as the current law stands, this student would be arrested, fingerprinted, have to spend money to make bail. The student would still, in turn, have to get his or her car from impound if it was during a traffic stop. The student shall be given a court date and go before a judge. If found guilty or the subject pleads no contest, the student will still face up to $1,000 fine and up to a year in jail. The student will also be subjected to 1 year of state supervised probation, which would require a monthly payment fee. Due to the infraction and potential time incarcerated, the defendant would, if they're a working student, lose his or her job for no call, no show. The student would potentially lose financial aid as well as potential scholarships. This student would then be potentially expelled and derailing any future plans for a successful career in innovative technology for the future. Earlier, you asked for the wisdom to make just decisions on the behalf of the people. Due to the current change in climate in our country regarding cannabis, I think that the wisest decision is to make the just decision that is apparent today. In regards to some of the things that were mentioned, data for new and current users in states, some of these data go back as far as 1986. There has been no significant data that would justify an increase or decrease in marijuana usage amongst college-age students, teenagers, or those at risk of addiction, in which we are here to talk about today. There has been no evidence to say that more college students now are smoking as opposed to when it was illegal, even in states where it has been legalized. In regards to the cannabis impairment, that would be a subject that we'll have to visit on each specific case. In regards to patients being threatened by a judge, I don't think that in regards to human rights and advocacy, we should even use terms like threatened, because if a person is stating that they have an addiction problem and they're coming before your courts repeatedly, the last thing they need is to be threatened with jail, because we know from statistics that jail only confounds upon addiction problems, because their addiction problems don't stop when they're incarcerated. They actually have to go through more to get those things to suffice that addiction. So we have to take a constituent look at this, and we have to take a well-rounded approach. I am in support of this bill, as Senator Jones stated. Some of us advocates are not as excited about some of the fines, but as a person who is a United States Navy veteran, a former Clayton County firefighter paramedic, and a current human rights activist, I am in support of this bill because I have been arrested for this plant 1 month after returning home from the Persian Gulf, and I do suffer from PTSD. If I confounded all of the fines, including the arrests, the probation, the court fees, I was over $3,000. So for people in that situation, I think that a $300 fine is a lot better than a $3,000 fine. Thank you.
Thank you. Any questions for Mr. Atkins? Thank you very much. Oliver Prosper. Good afternoon.
Good afternoon. Thank you, Mr. Chairman. My name is Oliver Prosper. I'm appearing today as a citizen, not representing any organization. I have law background. I'm also a graduate from Oxford University. I wanted to point out one aspect in regards to the fines and the incarcerations that are currently being applied in this situation. It costs the state of Georgia anywhere between $1,000 to $2,500 a month to incarcerate an inmate currently. And if you look at the minimum wage that is currently paid in Georgia, we can easily say that it costs more to the state to incarcerate somebody than to pay the minimum wage to do nothing. In a situation like this, it's very important to note that there's also a repercussion to their jobs and their lives that comes with the prevention when incarcerated, to where they a lot of times have to be in jail, lose their job for the amount of time that they spend in jail, and the rehabilitation that they have to go through after that often leads them deeper into other things that are way worse than what they started with. So I'm in favor of this bill, and I wanted to point that out to you just so that you know, considering forward that the cost to the state would actually be in a position where you would make money instead of having to pay to keep these people in jail. Because if you look at a situation where hemp is currently legal across the United States, I have seen CBD flower or hemp flower that legally tests at the amounts that it is to be considered hemp that looks identical to the stuff that is currently people are being arrested for. In a traffic stop, as a police officer, I would understand why they would decide that it's not up to them to determine whether that difference is. It's going to be sent to the GBI. You have to look at if that person doesn't have any money to make bail, the GBI is going to take 4 to 6 months to return with those results. So here's somebody who gets incarcerated for something that is perfectly legal just because it looks like something that is not illegal and is costing the state 4-6 months worth of incarceration when they could have just had to pay a fine and went on with their lives. So I want to thank you guys for introducing this bill, and that's my time.
Any questions for Mr. Prosper? Thank you very much. All right, Mr. Grigg, I'm not sure, is it Gerald? Yes. Step up, please. Good afternoon.
Good afternoon, Mr. Chairman, and thank you for allowing me to speak. And I appear in my civilian capacity, as I don't represent any organization with this testimony. And what I would just like for you to understand is that Georgia started a great track with the criminal justice reform under the previous administration. And I think that this particular bill will continue that track that needs to happen. I spend a lot of time in a lot of different communities. I also spend time in my profession as a criminal defense attorney dealing with these issues, going in and out of jails. And if we're really going to be serious about criminal justice reform, this is a good step in the right direction. As Senator Jones said, a lot of advocates and activists don't think it goes far enough. But I know Georgia, and I know that we take deference and sometimes a little time to catch on to what the winds of change that are blowing across the nation. But I just implore you to make this one step. I think that it will release the burden on many courts that are dealing with low-level drug offenders, where they can have an opportunity to either rehabilitate them or to give them a small fine. But I think that this particular bill is a step in the right direction. I would implore you to pass the bill. That way we can continue on the path the previous administration had for criminal justice reform, starting with this particular bill. Thank you.
Any questions? Okay, thank you.
Thank you
very much. Mr. Is it Bruce? Chris Bruce?
Thank you, Mr. Chairman.
You're
members
welcome.
of the committee, good afternoon. My name is Christopher Bruce. Maybe I should sit down first. There we go. My name is Christopher Bruce. I'm the Legislative Director of the American Civil Liberties Union of Georgia. It's a pleasure to be here in front of you today and to speak about Senate Bill 10. So there are several reasons why this bill should pass the Senate Judiciary Committee, as it did 2 years ago. But in my limited time, I want to share a story with you. A gentleman was arrested for the distribution of marijuana and released immediately. 2 years later, after having his 7th child, after finding stable job employment where he could provide for his newborn child, his 6 other children, and his wife, and other family members, a district attorney decided on taking his case to trial. When approached with this district attorney and saying the situation that he was in, including being the primary caretaker of this infant, the district attorney said, well, it's just going to be a hard time for his family. It's just going to be a hard time for his family for a while. For a nonviolent offense of a person who actually did community service after being released, for an individual who's actually still in jail at this time, and his mother, his wife, had to quit her job to now take care of her family, who had to move back in with with her parents. You have taken a productive, not you, excuse me, this law, as it's currently written, takes away people who are productive citizens in the state of Georgia and puts them in jail as a tax liability, because we're paying for them. We support Senate Bill 10 and saying that we need to move forward step by step, and saying that nonviolent offenders should not be in jail in any way or fashion. Thank you.
Any questions? Thank you very much.
Thank you.
That's all I have signed up. Did anyone else want to be heard? Okay. All right. That's the conclusion of testimony. What's the pleasure of the committee? Motion by Rhett.
Second.
Second by Parent. Discussion. Senator Cowser.
Thank you, Mr. Chairman. I guess I need to apologize to the author and to you, because I have represented to both of you earlier that I was okay with this bill, and we passed it out of my subcommittee yesterday, referred it to this committee. But after hearing this debate, I think there are a lot better ways to do what you're trying to accomplish, which is essentially to lessen the penalties for possession of very minimal amounts of marijuana. I'm troubled by the fact that the penalties will remain harsher for underage possession of alcohol than they are for less than a half an ounce of marijuana. I'm troubled by Senator Kennedy's comments that you could commit this offense an innumerable amount of times and the penalties don't escalate. I'm worried that there's no provision here for any mandated counseling, treatment, or whatever, because without the potential for incarceration, there's no potential for probation that would supervise that type of treatment. I don't know that we as a society have addressed the fact of whether or not we believe marijuana is a gateway drug to further drug usage as we're facing this opioid crisis or not. I don't really know. I like some of the provisions of the underage possession of alcohol statute, and that's 3-3-23, that has a first offender provision in it that we don't have here, and I'm sort of thinking that might really get where you want to go, is let this a first-time offense be handled under a first offender type process where you don't come out of it with a conviction, where this you do have a criminal conviction for a misdemeanor. So I'm almost arguing for you to take it further there, but of course you could only do that one time, so it's a one-time pass. And I'm struggling. I know on that type of offense we have an automatic almost expungement or restriction from your record, and I think Senator Strickland was referencing that. I mean, if this is so minimal, we're going to let somebody off with a $300 fine. Why do we want them to carry it with them the rest of their life and have trouble in employment or whatever, having that conviction on their record? So as my mind is sorting through this, I'm seeing a whole lot of perhaps better options, but I don't have enough time to coherently prepare an amendment to help you with that here. So I just wanted to let you know why I'm not following through on my earlier commitment to you that I was okay with this bill. It's only because I think there's a better way to achieve your objective if we would spend a little more time and be a little more deliberative with this through some combination of those suggestions that I just made.
All right. Senator Strickland.
Thank you, Mr. Chairman. Along those same lines, I would request that the author agree to hold this bill a little bit longer. One thing that's sticking with me is whether or not this may impact any medical marijuana bills we currently have, any laws we currently have in the books, when that was raised a minute ago as far as the notwithstanding language. But I would just request, and I'll make a motion that we table the bill to give us a little more time to continue those conversations, perhaps through next week.
Any objection to considering a motion to table? Is there a second? Second by Ligon. Discussion. All in favor signify by saying aye.
Aye.
All opposed, like sign. Bill is tabled. All right, the next and last bill on the agenda is SB 38, Senator Ligon. You want to stay seated? Go ahead, whenever you're ready.
Thank you, Mr. Chairman. This bill is making an amendment to the e-filing bill that was passed last year, and it comes because of some experiences that have been brought to my attention. I've been working with some of the judges of the Superior Court. We've had input from the Clerk's Authority. Is that right? Yeah. Clerk's Council. And basically what the bill does, if you look on page 2, beginning with lines 35 through 37, it's giving an attorney the option of filing leave of absence or conflict letters either electronically or by filing it with the clerk's office by paper. And I understand that at times, although this has never happened to me, there may be a need to file a conflict letter in a case that's not been assigned yet. And in that case, you really can't file electronically. And so it's a vehicle to allow that to occur. Then in the next section, we're exempting certain filings from paying the filing fee when they're filed electronically. And those are pleadings or documents by the Attorney General, Secretary of State, District Attorney, or Public Defender. Their leave of absences and conflict notices. And then in lines 45 through 47, sometimes there are grants that pay for these filings, and this would allow those payments to be continued if there are grants that allow us to do that. There was a requested amendment that's in the file, and occasionally I understand that county governments have to make filings. They're asking to be included within the category of the exemption that we're giving to the Attorney General, District Attorneys, and Public Defenders.
Let me stop you, Senator Ligon. You're operating off LC 41-1765S?
Yes.
Okay. All right.
That in the amendment. That is a different LC number. Okay.
I think it's going to be 41 and 42.
That's right, the amendment states that we're amending lines 40 and 41, but it would be lines 41 and 42 by inserting, let's see, by deleting, or after the word public defenders, inserting the words or county government, and we'd have to delete the word or between attorney and public defender on line 42.
All right, that clears up what you have in your folders. The amendment that he was alluding to referenced a different LC, but I believe that's been covered.
Mr. Chairman, I don't know if on the amendment, if we have to reference the correct LC on that amendment as well.
Might.
And that should be, the correct reference on the amendment should be to LC 41-1765S instead of 1754S.
All right, you want to continue?
And then we'd have to, replacing lines 41 and 42.
Let me ask you, about the amendment. It has political subdivisions, and then again it has county government. Is that? It does not have municipal government. And do you think that's the best way to word that?
Well, I'd have to, I mean, we may want to include municipal governments as well.
Well, they're political subdivisions.
That's right, they are.
All right, Senator Parent.
Thank you, Mr. Chairman.
Hold on. Were you through?
Well, Senator Tillery mentioned that they're municipal corporations.
Yeah, would they be municipal corporations?
I thought they were.
Not political subdivisions? Didn't think so.
All right. All right, do you wish to continue?
I'm gonna need to think about it for a minute.
Well, while you're thinking about it, can I call on Senator
Please
Parent?
do.
She wants to be heard.
Yeah.
All right, go ahead, Senator Parent.
An extremely hot question that I have. For the amendment, would we also need to swap out lines 111 and 112? Or no?
Probably would have to do that. We would.
Okay. Thank you.
So the same amendment would be on lines 111 and 112.
All right. All right, does anyone else wish to be heard? We don't have anyone signed up to speak. What's the pleasure of the committee?
Move to pass.
Motion for due pass by Calzert, Senator Kennedy, or Strickland. Second, right?
I'll make the second, but I'll also push for discussion and a possible amendment.
All right. All right. Is there any discussion on the amendment? Senator Strickland?
Not on the amendment itself, on the bill. I had discussion. I'm sorry.
All right.
I'm ahead of myself.
Okay. Any other discussion on the amendment? We're going to address the amendment first, and then the bill is amended.
Mr. Chairman, in response to your question, I'd rather just proceed as it is right now, unless you have a different suggestion on the amendment, instead of adding the municipal
Okay.
subdivisions,
All
because
right,
it may be
well.
covered under political subdivisions.
Well, that
We'll find out soon enough.
Legislative Council begs to differ.
Does he? So does he have, if he has a suggestion, we'd sure.
I think if you wanted to include, I think if you want to include cities, probably the best way is to state it, because they.
Well, then let's state it.
Yeah.
And,
Municipal.
and the best way to state it would be municipal corporations?
Yes.
Okay.
Okay. So we could add municipal corporations after public defenders.
All right. Senator Strickland, you offered the amendment. Or did you? No, you seconded. Calzert, you offered the amendment. Are you okay with that? All right. A friendly amendment amended. Okay. Any further discussion? Senator Tillery, excuse me.
Mine was going to be as to the bill, Mr. Chairman. If you're wanting to vote on the amendment, I'll wait till after we vote on the amendment.
All right. All right, any further discussion on the amendment? Hearing none, all in favor signify by saying aye. Aye. All opposed, like sign. Okay, so we have the LC 41-1765S as amended to create a new substitute, and I believe there's some discussion. Senator Tillery, did you want to be heard?
Sure, Mr. Chairman. Thank you. Question, I don't know if it's for the author or who it would be for, anyone in the audience. I'm reading on lines 45 through 47 when we of 1765S. Is there a grant program in place to refund the cost for this already?
I'm going to call
I'm reading on what I'm reading, Mr. Chairman, is it says that the clerk or electronic filing service provider may recover the cost of any fee provided. So obviously there's no free lunch. Somebody's got to pay it somewhere. Is there a grant in place already to?
I'm going to call on Mr. Holloman.
And I will be glad to respond to the committee. I think that Senator Ligon put that language in because we were talking about keeping child support enforcement filings from having a charge. And he was looking at putting language in there that would accomplish that. I just cautioned that he should talk to the administrative office of the courts who have a contract with child support enforcement to provide e-filing services. And I'm not a lawyer, they said, just be sure you don't mess up their contract. And I think this is his attempt to ensure that he didn't inadvertently cause that contract to come into question. That's all I know about it.
Does that answer the concerns? Anyone else? All right. Senator Strickland.
Thank you, Mr. Chairman. Going back to at the subcommittee, not everybody was here, I asked about lines 35 through 37, which is taking the leave of absences and conflict notices out of the mandatory e-filing. And what the question asked in the subcommittee was, well, the point I think I made is I don't know of any time that you would file a leave of absence or a conflict letter when there wouldn't be an open case. There was conversation about whether or not there'd be actual case to file under with e-filing. But every time there's leave of absence or a conflict letter, it's still noticing a certain case. And the Superior Court rules require an interim appearance first before you would file that. But even if that's not the case, under the e-filing bill we had, if there's not a case open, the e-filing mandate does not even apply. There's no civil filing even there. So I think if there was a scenario where you wanted to file a conflict letter or a leave of absence, but you don't have a case number, you'd have to submit that to the clerk and it'd be filed the traditional way. So what I was going to propose, an effort to continue uniformity, is that we strike lines 35 through 37, but leave this still free of charge. And Senator Cowles made a good point of the high costs he had in filing his leave of absence prior to session. And that's something, too, that an attorney really can't pass along to a client. It's a fee that they incur for their leave. And so I think the good compromise is still make it mandatory so there's a uniformity there. You can still see a conflict letter before court online, and a leave of absence still be assessed through the same process, but make it free. Leave 45, we'll leave actually 43 and 44 there. So the appropriate time, I'll offer an amendment to that effect.
Now's a good time.
So we'll strike lines, and make sure I get this correct. First off, on line 30, delete, actually reinstate the "or" at the end that's been deleted. At the end of line 34, strike the semicolon and put a period, and then strike lines 35 through 37. I think that will accomplish that.
All right. Is there a second? Second by Tillery. Any further discussion? Senator Cowser.
I just got a question to make sure. The net result of your amendment, you still would not have to pay a filing fee to electronically file leaves of court and conflict letters?
That's correct.
Yeah, that's covered, I believe, on lines 43 through 44. Go ahead.
I don't have an objection to the amendment. It's just if Senator Strickland can't go on vacation, then please don't blame me. I tried.
All right. All right. All in favor of the amendment signify by saying aye.
Aye.
All opposed, like sign. Okay, that returns us to the main motion. Any further discussion? Senator Tillery.
Thank you, Mr. Chairman. I bring up again, I point out those lines, again, 45 through 47. I see it here again. My concern is that we're making it free for the Attorney General, Secretary of State, but then somehow through appropriations, through a line item there that it says something about where this has been appropriated for filing fees, that they somehow get charged. And I don't know how to, on the spot right here, fix that, but I just want to point that out to the committee to be looking at as we move forward.
All right. Just a moment.
I think I left out amending the part that deals with state court filings. Did you just note that?
We were just talking about that.
So
All right, so you want to make a motion there?
I'll make an additional motion. If I miss something else, y'all please let me know. And so we'll have to reinstate the or on line 100, strike the semicolon and the or on line 104, replace it with a period, and strike lines 105 through 107.
All right, is there a second? Second by Tillery. Discussion, hearing none. All in favor signify by saying aye.
Aye.
All opposed, like sign. All right, back to the main motion. Any further discussion? Hearing none. All in favor signify by saying aye.
Aye.
All opposed, like sign. Okay, that concludes our business. Unless there's anything else to be heard, we're adjourned.